Well, I think they should be contacting a lawyer, because what they're getting is a legal offer to make a contract. And what they're being doing is asked to contract potential rights that they may have. So some employees may be entitled up to 24 months severance, and they might be only offered 8 months or 6 months. So they should get a proper legal opinion to determine if the offer being made to them is in the range or in the ballpark. Probably not enough. What you see with some employers is that they will play the odds. They know that a small percentage of employees will actually go and see a specialized employment lawyer and get a proper legal opinion, even though ironically that's exactly what the employer has done in advance, because the employer will know what its obligations are. So the employee should have the same amount of knowledge that the employer does, or I should say former employer. Well, they're thinking dollars and cents, and they know they have a legal obligation, they have a legal exposure, but they're trying to reduce it, and that's why they make the offers that they do. You know, the reality of the situation is that you're in an adversarial business relationship with your former employer, and the less money they can pay you, the more money for the shareholders and executive bonuses. So if you're the employee, you probably want the money for to cover debts, cover emergencies, to pay your mortgage. Well, the problem is that a lot of them don't understand that the employer is not their friend. They're no longer an employee, they're a former employee, past perfect tense. People pay money because they know bad things can happen to them. And one bad thing that could happen to employers is that they could have to go to court and pay the employee's legal fees. The employee acting for himself does not have the same bargaining power, because the employee cannot go to the Superior Court himself, practically speaking, and commence a wrongful dismissal action against the employer. So the employer has to know bad things can happen to it, and because they know they could face exposure, they're more inclined to pay the employee what he or she should be getting. What happens is that if you get a severance package, it basically causes the EI system to get frozen, and it's suspended until the end of the severance term, and then if you're still unemployed, you get EI. Right. So basically it throws back the time before you can collect it. So let's say you have 12 months severance. Well, the time to collect EI is suspended by 12 months. Normally I write a letter and they get a bearer package. If I don't, I sue, then they get a bearer package either initially or after mandatory mediation. Well, first of all, because the employer has proved cause, because the employer has proved the employee has not mitigated his or her damages, it's hard for an employer to win. And so because of that, maybe 5% or less of cases go to trial. And because most cases settle, that means you make a bargain, you negotiate an agreement, you can negotiate all kinds of terms, including a good reference. And so that would be normal, that the employer will not say anything negative about the employee to any prospective third-party employer. Right. So that's a good reason to retain counsel, so you can negotiate these kind of things. Well, I think it's, like I said, I think it's important to be on a level playing field with your employer. It makes sense to retain counsel. The amount at stake can be quite large. I mean, if you're getting 15, 20, 18 months pay, that could be like similar as a small piece of property. So you want to do it right.